Hey guys, and welcome to today's video. We've got a couple of court cases to cover today. The first involves a pro se defendant who genuinely believes he understands the law better than trained attorneys. The second features a self-described insane sovereign citizen who goes head-to-head with a new judge and attempts the only sovereign-style defense that ever almost works, pleading insanity. We'll start with the first sovereign citizen, who actually gives us two hearings to break down, one from about a month ago, and another from just yesterday. So with that said, let's get into it.
Turning to Ronald Hargrove.
Jonathan Baber on behalf of Mr. Hargrove.
All right. Is Mr. Hargrove here?
I do see a Ronald Hargrove name. There we go.
Okay.
Judge.
I think I just heard him. He's coming on. All right. Okay,
Thank you, Your
Mr.
Honor.
Hargrove. Go ahead, Mr. Baber.
Yeah, today is the date and time set for a couple of things. It's a status conference, Judge, but it's also a hearing date for my motion to withdraw. I'm really just going to rest on what I put in my written motion for this court. I really can't disclose too much more in regard to what the conflict is between me and my client without risking attorney-client privilege, and I don't want to waive that on behalf of Mr. Hargrove. But I do believe there's been a breakdown in the communication between me and my client. We just aren't seeing eye to eye on certain aspects, and I want to respect his wishes on how he wants to have his case represented. So therefore, I'm asking this court to consider withdrawing me from the case.
All right. Mr. Hargrove, well, first of all, Mr. Baber, you are appointed to represent him. Is that correct?
I
Yeah,
am.
I do see that in your motion. Okay, give me just a second to.
And I want to stress to the court too that Mr. Hargrove has been very respectful. It's just a situation where we just do not see eye to eye on certain things.
All right. So, Mr. Hargrove, you understand what, without getting into details, because I've read the affidavit of Mr. Baber, but do you understand what he is saying?
Yes, sir.
All right. Now, if I allow him to withdraw, which is what I'm leaning towards right now, I'm not sure whether there will be another attorney appointed for you or not. I don't know.
No, I was just confused about a bunch of things.
Right. But, when there's a significant disagreement as to how to proceed, an attorney cannot go ahead and present something to the court that the attorney believes is not justified by law or fact, even if his client thinks it is. So he can't do that if he believes, that's against the rules that we have to practice under.
Okay. Well, let me ask you a question.
But you can ask it, I'll answer it if I can.
Are you the trustee for the Sesta KV account, Ronald Gene Hargrove II, or any account thereof?
Are you asking me that question? I have no idea what you're talking about.
Yes, I do. Some sovereign citizens believe that by naming the judge as the trustee of their so-called trust, they've created a conflict of interest that would force the judge to step aside. To put it simply, no, that doesn't work. The judge is not your trustee, and this claim does not create any conflict of interest or require recusal.
You don't know
I
what I'm
suspect the answer is no, but we're really not going to go down that road. Right now, the only question is whether or not Mr. Baber should be your attorney or not. He's filed a motion to withdraw, saying that he can't, basically you have a disagreement on how to proceed. That's too significant for him to proceed.
Okay.
All right, so I'm going to allow him, Mr. Baber, was there an order that accompanied your motion?
No, Judge, I will prepare one and present it to the court by tomorrow.
All right, that's fine. I'll go ahead and sign that. Mr. Hargrove,
Yes, sir.
you wish to have another court-appointed attorney?
No,
Or do you want to represent yourself or hire your own attorney?
well, I guess I'm not going to get anywhere. No, my questions aren't being answered. So I don't know what to do.
Well, I need an answer. If you want to request another attorney, I can have, I can have you interviewed again by MIDC. They may or may not appoint an attorney for you or allow one. What do you want to do?
Well, um, I guess I'll go forward with an attorney and
Okay,
because
so here's,
I have a a witness and some other things.
okay.
I guess I need an attorney.
There's no guessing here. You sound completely unprepared to handle things like serving subpoenas or presenting evidence on your own. For your own good, it's time to stop firing your attorneys and let them do the work they're trained to do.
Well, I mean, it's up to you. I'm not necessarily going to appoint one for you. Ms. Parker, is Mr. Brown there?
Yes.
He is. He just popped on. Mr. Brown, this is a bit of a new one on me. I don't know if you heard it all. Mr. Baber was appointed to represent Mr. Hargrove. He withdrew because they had some disagreement on what should be presented to the court. And I've allowed the withdrawal. Mr. Hargrove still wants a court-appointed attorney. Does that have to go to Mr. Slough, or is he simply re-interviewed by you?
I don't necessarily know if he even needs to be re-interviewed unless things had significantly changed, as he did have a court-appointed attorney. So unless things have significantly changed, I don't think a withdrawal would require a re-interview. I think he would just have to be appointed another attorney.
All right, so we'll notify Mr. Gilo's office of that. Mr. Hargrove, that attorney would be appointed for you. You'll be given the name and number of that attorney. You should give them a call. Pam, if you call, or that attorney would do, also let them know they may want to call Mr. Baker.
I'll try to remember.
Yeah, okay, I get it completely. But Mr. Hargrove, I suspect that if this attorney has the same situation that Mr. Baber does, you may end up representing yourself or having to hire your own attorney.
Well,
okay.
I wish you would just please answer my question.
Well, that's nothing that I can answer in a situation like this. The only question, you need an attorney, you've requested an attorney. If the next time you come to court, I won't be here because there'll be another judge. As my term ends at the end of this month, in about 10 days or so, 12 days. So any argument would be presented to them, but it has to be done according to the court rules that we're all bound by.
So you don't have to answer my question?
No, he doesn't, especially since he's retiring at the end of the month and a new judge will be taking over. Speaking of which, let me introduce Judge Hesselink, who assumed Judge Cooper's bench about a month ago and is already handling his first sovereign citizen case. This time, the defendant has a lawyer, but that hasn't stopped him from completely messing things up for himself.
All right, Ronald Hargrove, file 24-43189 ST. I see you, Mr. Hargrove, on Zoom. You represented by counsel, Mr. Hargrove?
I represent Mr. Hargrove, Judge.
All right, thank you.
What we're going to ask the court to do is accept the plea to count one with the second offense dismissed.
Mr. Fortier, is that an accurate statement of the agreement?
I don't know yet, Your Honor. I can't find the case for some reason.
All right, I'll give you a second.
Mr. Gilo, did Ms. Brooker email you that offer?
Yes, on the 9th.
Okay. Then yeah, Judge, that would be what we're gonna do then.
All right. Mr. Hargrove, you've heard the attorneys talk that there's an agreement being offered to you that if you plead guilty to the first offense of operating with your license suspended, the notice for second offense, which enhances the penalty, would be dismissed. Is that what you want to do? You're on mute now, Mr. Hargrove. You're gonna have to take your, there you go.
She
Is that what you
muted.
want to do today? I'm sorry.
I just had a few questions.
Well, you're gonna need to talk to your attorney about those questions. Do you need some time to do that?
He can't answer them for me.
All right, well, then what are your questions? Let me see if I can answer them for you.
Okay, well, I don't understand how you can be the trustee of my SESTA KV account, Ronald Gene Hargrove II, and not have my best interest.
I'm sorry, what, I don't understand what your question is.
How can you be the trustee of the SESTA KV account, Ronald Gene Hargrove II, and not have my best interest?
What is that account that you're referring to?
Oh, God. The SESTA
Yes,
KV
it
account
is, but
that
go
everybody
ahead.
most people have, and you're the trustee. Just like the Secretary of State is trustee of it. You are my trustee, aren't you?
No, and neither is the Secretary of State. This judge is relatively new, but is handling this oxygen thief quite well. So naturally, it's time to ask the question everyone wonders. Have sovereign citizens ever actually won a case using their usual convoluted arguments? The short answer: no, not once.
Not that I'm aware of.
Uh-oh.
Why would I be your trustee? Mr. Gila, do you have some additional information that I'm not picking up on?
No, Judge.
It's just something that I believe in, and I've seen evidence of, and
What leads you, Mr. Hargrove, what leads you to believe that I'm your trustee?
because of a former case I've seen.
A former case, what former case are you referring to?
In Roscom, and a friend of mine asked the judge that, and he couldn't answer him. So
That's probably because it's not factually true. What information do you have that leads you to believe that I'm a trustee for you?
In that case, the judge quit 6 months into his new term because he was dishonored, and the sheriff.
I'm going to need solid proof before believing that some sovereign citizen magically discovered a loophole that let them avoid legal consequences, and somehow got a judge and a sheriff removed in the process. Without evidence, it's just another tall tale.
So,
Mr. Hargrove, the question was not about a Roscommon County case. It was about this particular case. You've alleged that I'm your trustee. I'm asking what information or proof that you have that is true.
so you're just denying it?
I don't know of any information that it makes it true.
Okay. If it was
What information do you have?
If it was a misdemeanor,
go ahead.
If it was a misdemeanor, would it be true?
No. Misdemeanors and trusts have nothing to do with each other.
Okay, well,
there has to be some court order for me to be a trustee for you. For anybody to be a trustee, there has to be a court order. Do you have such a court order?
no. I just believe that you are my trustee of the SESTA KB account, Ronald Gene Hargrove II, and that's.
Could you speak a little more clearly and tell me what that account is?
I'm not sure. I just believe that you are my trustee, and if you deny it, then you deny it. Okay, we'll move on from there. I guess, and another thing is I paid $1,000 for a reinstatement fee, but you guys keep saying I don't have a license. And where did my $1,000 go? I don't understand this.
Who did you pay $1,000 to, Mr. Hargrove?
The Secretary of State or the
Then
state
you need to ask the Secretary of State.
Well, I believe I have my license, and they just keep, there's a screw up somewhere.
Then you need to contact the Secretary of State, but I'm not connected to the Secretary of State. I'm the court system. I work in the court system. I don't work for the Secretary of State, so I can't tell them what to do. If you believe that you paid the money and you should have a license, you need to contact the Secretary of State.
Okay. Well, knowing that I think I had a license at the time, doesn't that change things?
It would change things only if it were true, and I don't know that it's true.
I
Just
don't either.
because you believe it doesn't make it true.
Yeah.
Well, thanks a lot, Judge Hesselink. You've been on the bench for less than a month, and you're already putting an end to the unrealistic expectations of gullible people who think they can ignore the law.
All right, Mr. Hargrove, your attorney has told me, and the prosecutor has agreed, that there is an offer on the table for you to plead guilty to operating with license suspended in exchange for dismissal of the second offense notice, which makes this a much more serious charge.
Okay.
Do you want to accept that today, or do you want to have some additional time to speak with your attorney?
No, they don't have nothing to say to me. Their best interests is of the court. So I'll take that, and I would hope to get the same fine everybody else did today. Thank you very much.
Well, I can't guarantee that because you're in a different circumstance than everybody else.
Well, I'm pleading guilty to the same offense they just pled guilty to.
But your background is not the same as theirs.
You know what? I'll plead insanity.
All right, now that makes sense. That wraps up this hearing. It was rescheduled for a couple of weeks from now, and honestly, I can't imagine the next appearance being anything less than chaotic. Next, we move on to a young man who insists he can prove his innocence with facts and testimony, but refuses to accept help from the public defender assigned to his case.
What's your name?
Oh, you were up for an arraignment this morning.
Yeah,
that was at 8:30.
Yeah, I dropped my son off at 8:30. I didn't know because the court didn't open.
Okay, so what we have to do,
I'm trying to figure out how to get it.
Well, I don't think you're gonna. You're not gonna. I don't think you're gonna. Are you gonna have time to address that? You want to go through an arraignment?
Please.
That's fine.
Thank you.
Then you go discuss it with Mr. Sierra. What's that?
We talked.
You already talked? All right, well, let me finish.
Form's already submitted.
Okay, let me take care of these here quick and I'll get right to you. Let's go in the record in the matter of People State of Michigan versus Brown, file 2444177FY. And state your name, sir.
Quentin Brown.
Assistant Public Defender Dario Sierra appearing on behalf of Mr. Brown for the purpose of arraignment.
Very good.
We have reviewed that felony file. I waiver reading at this time. I'm speaking with him. He had asked it a set for the probable cause conference in the prelim. After he has just advised now that he would like to self-represent. So court-appointed attorney is being denied by Mr. Brown.
Well, it's not being denied.
He was previously
declining
granted,
to accept it.
so
All right. All right. You sure about that? You want to represent yourself when someone goes to school for many years to learn how?
I know what's going on better than anyone that can, because it's not right.
I know it's a bit hard to follow, but it seems he's upset that his defense attorney received a plea offer from the prosecution and simply passed it on to him for consideration. The attorney didn't accept it. They just did their job, which is literally their obligation. He seems to think the public defender accepted a plea on his behalf without consulting him first. But as you'll see, that's far from the only misunderstanding he has.
It is your right. It's your absolute right to represent yourself. The point of I just want to.
I got proof.
Hold on. Okay.
I just want to prosecute my case.
Okay, and that's fine. I'm just gonna right now. What I say now for the next moment is going to be something I want you to listen to, only for the sake of protecting you. The only reason I'm making the statement is to protect you from yourself, which I have to do a lot with people. Okay, so this is not just a matter about you. It's about anyone that wants to represent themselves. I go through this with. Okay, and what I want to be sure is to not have you make statements right now about the case, because we're on the record and I don't want anything you say now to be able to be used against you as you go forward. Okay, that's just to protect you. That's the only reason I'm saying that. All right. What I want to also go into is the fact that I'm going to give you the spoiler alert. You absolutely have a right to represent yourself. So I'm not going to, you're going to have that right. But I want you to be very wide-eyed and thoughtful about whether or not you want to have someone who is who does this for a living, who is here. They know all of the laws. They know all of the various potential defenses and discussion points that they could have with the prosecutors to probably assist you in using your knowledge. So if you say you know all there is to know about your specific case, and that's probably true, no one would know that better. But if you combine that with the know-how of a prosecutor, of an attorney,
they won't represent me like I'm innocent and protect me like I own my life and my freedom.
My understanding of the quality and caliber.
They offer me deals and the prosecutor and I'll never get the chance to speak to them.
Yes, you have the right to represent yourself, but just because you can doesn't mean it's a smart choice. It's like having the right to jump off a cliff with a rocky bottom. It doesn't mean you should. That I understand your position. You genuinely believe you're innocent and think you have all the evidence needed to prove it. The problem is that proving innocence in court isn't just about having facts, it's about following strict rules so your evidence is actually accepted. Lawyers know how to navigate these rules because it's their profession. That's why judges always advise, even those who insist they're innocent, that it's in their best interest to let an attorney represent them, rather than trying to handle the case alone.
They have an absolute requirement when the prosecutor makes what is known as a plea deal or a plea negotiation. They have a responsibility. They have ethical responsibility to share that with you. That's your decision, but they have to present it to you, at least for you to make that decision. But when I appoint an attorney to represent you, you're that attorney's boss. And if you decline a plea negotiation, then it's declined. That's up to you, not to them. So, like I said, I'm gonna go ahead and indicate here that you wish to represent yourself. That's fine if that's what you want, but I would be thoughtful about that, because again, this is what they do for a living. You know what I'm saying?
Well, I know in court that they had to find me beyond reasonable doubt, guilty beyond reasonable doubt.
That is
so
true.
I feel comfortable representing myself because I know for a fact I'm innocent and I haven't committed any crimes.
Okay. Well, but that's fine. We can
else you can represent me, they don't know. They don't know.
Well,
100%.
But
they can go home and sleep and be like, they don't know me.
Okay.
They don't know.
All right.
If I did these things.
Here's the thing. What happens though at a trial, if you're representing yourself, and again, the end result of this is you're going to be able to represent yourself if you want, but it's going to be not you, it's not going to be a judge, and it's not going to be the prosecutor that makes a decision as to whether or not you are indeed guilty. It's going to be a jury.
I know.
And they're going to have to, and they're
going to be you.
It's not going to be me.
Or whatever it is. I guarantee you will be changing this verdict after I got what I got to say.